Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists and uncertified podcast co-hosts. We try to bring our audience of trial and appellate attorneys some news and insights they can use in their practice. If you find this podcast useful, please recommend it to a colleague. If you don't find it useful, there's always opposing counsel.
And thank you to our sponsor. Our podcast is sponsored by CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber since 2019, and I highly endorse the service. And listeners of our podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/kelp. That's casetext.com/CALP.
And today we welcome Greg Nylen to the show. Greg Nylen has more than 29 years experience in litigating complex commercial cases involving intellectual property, entertainment litigation, and anti-counterfeiting enforcement for luxury brands, food and beverage law, class action defense, and general business litigation. Greg is the co-host of the California Unfair Competition Defense Podcast, which provides in-depth analysis of new developments in case law and defense strategies relating to California's unfair competition and consumer protection statutes, including Business and Professions Codes 17200, 17500, etc., and the Consumer Legal Remedies Act. Greg, welcome to the podcast. Thanks for being here.
Thank you. Appreciate it.
Was there anything in that short bio that I read of you that I left out for the good of the record, for the good of our audience?
I think I do a lot of intellectual property litigation. I think you covered that, but there's some overlap in the sense that trademark for litigation, for example, turns on the question of likelihood of confusion, which in turn looks at what reasonable consumers believe. So there's a lot of overlap between the fraudulent prong of the UCL and trademark litigation in that sense.
Yeah.
So that's a lot of my wheelhouse too. And also I've been practicing now. I realize I have to update my bio because I've been practicing for 32 years now, going on 33. So that needs a little adjustment on my end.
Sure. Well, and at the end of your list of many practice areas, you include the umbrella term, the business litigation, like the 2 million or so others of us who do business litigation in the Los Angeles metro area. Tell us how you developed your niche in unfair competition law, which is a subject that we'd like to talk about today, given that you recently published an article about recent trends and updates in that space, unfair competition law.
Well, I've had two phases here at Greenberg Traurig. One phase was I was a shareholder up in LA for 12 years and associate for a couple of years before then. Was there when they opened the LA office from day one, January 1st, 2000, and lived in LA for 36 years, where I went to film school before law school. And while I was in LA, I started defending a number of consumer class actions involving 17200, 17500, the triumvirate, if you will, is what I call them, and CLRA. They seem to go together like peas and carrots. Although, and we'll get to this, I think Sonner may be helping with that to some degree, but in terms of them all being lumped together. So
Sonner, you're talking about Sonner versus Premier Nutrition Corp, the Ninth Circuit case.
Yes.
Yeah, we'll talk about that a little bit later on. Yeah.
So I did quite a bit of litigation in that regard when I was in LA during my first stint at the firm, and then decided, of all things, to follow a passion and open a brewery in Orange County, which I co-founded and along with my wife and ran for about 5.5 years. We were the first in Costa Mesa of our type, and we did that, and we got out of the business just before COVID hit. I kept practicing law during that time. I had trials during that time, arbitrations, you name it, but it was at a small firm that a friend of mine I knew from law school had, and after that I came back to GT, but in Orange County. So now my commute's 7 minutes instead of an hour and a half each way.
Yeah.
So
well, that's amazing. So you had a film school background before law school, and then as a practicing attorney, you started a brewery. So you're all over the place as an entrepreneur, a fan of the arts. You find you're able to bring it all together in your legal practice? Do you kind of touch on all of your passions there?
Yeah, I mean, the first 10 years of my career, I did entertainment litigation primarily. up in Santa Monica before coming to GT, and so that involved a lot of really interesting cases and clients and issues: right of publicity, defamation, false light, invasion of privacy, public disclosure of private facts, a lot of Civil Code Section 3344 stuff, as well as IP litigation, trademark and copyright, and that kind of thing. The 1700s 200 stuff came in more when I joined GT, and then during my first stint, I would write on the subject. I did a yearly update on the law for the litigation review that the litigation section of the state bar produces. It used to be called the litigation section. They've changed how that's organized, but I was the chair of that section for a year, and an officer before then, and a member of the executive committee before that. So I got very involved in, writing about the statute, and did some kind of the old school panels, before the age of Zoom, and wrote some articles about it.
Yeah. Well, and at some point you decided to start co-hosting the California Unfair Competition Defense podcast. What spurred you to start that podcast, and what kind of lawyers should be tuning in to the California Unfair Competition Defense podcast?
What my co-host Lisa Simonetti and I, who is also at GT, she's a shareholder in LA. We both recognize that there's a need for some sort of information source for people defending against these claims, and there really wasn't any consistent blog that we could find in that regard. There are plaintiff side blogs, but we saw a need for this kind of information on the defense side. And in this day and age, we thought a podcast would be something that would be probably consumed more frequently by people than a blog that's just printed. People can listen to, I do a lot of cycling now, and I listen to stuff when I'm cycling. I don't listen to music. I listen to people talking for the most part. And if my own experience is any guide, and I was certainly told by our marketing people that's the way it is now, the podcast is a better way to go.
Yeah, that's interesting. I hadn't thought about what you just mentioned, that there are more resources for the plaintiff side in these cases than for the defense side. So you said that you found that there were several unfair competition blogs that were geared toward prosecuting those kinds of claims, but not so much for the defense side. What explains that, other than, I guess the kind of the jackpot mentality? If you're going to go and work on these cases, you want to be on the side that stands to win the big money, big money.
I don't know. I think there are certainly plenty of articles about particular issues. Like when a case like Sonner that we talked about comes down, you'll see a bunch of law firms will write about it, from the defense perspective, and then that's pretty much it, as opposed to just talking about these issues on a consistent basis.
Are there any types? If there's one thing that you wanted attorneys to remember from your podcast, or to take away from listening to the California Unfair Competition Defense podcast, what is it? What types of doctrines or cases that defense attorneys really need to be aware of that maybe they're not, if they're just kind of coming out of the box and they don't have any resources before listening to your podcast?
Yeah, I think the to be aware of the most recent developments in terms of how courts are viewing both sides of the battle, really. But it's just really important to stay on top of things, because it changes so rapidly in this area. And when you have a case come down on one particular issue, like I just looked today, Sonner has 309 federal court decisions following it already, or applying it, in various contexts. And that case is 2 years old. So it's really important to hear where the splits are, where the undecided issues are, but to hear about, some ideas and consensus and how to address new angles and new attacks that the plaintiff's bar is trying, in these, what I call no injury cases, that's in particular, the alleged false advertising and that kind of thing.
Yeah. So you describe it as no injury cases. These are like these statutes are they're developed for the purpose of public policy to foster, truth and fairness in advertising, not necessarily to prevent injury. So that's makes it a little bit of a novel area of law, I guess.
Sure.
As you said, it's important to know about where the trends are, where the splits and unanswered questions are, and that's a good segue into talking about your recent article published in the OCBA Lawyer magazine entitled "Recent Developments in California Unfair Competition Law." And in that article, you note that the courts are always busy interpreting the statutes under the unfair competition law, located under the Business and Professions Code. And among those many decisions, you spotted 3 trends in unfair competition law. Can you tell us what those trends are?
Sure. I mean, I think one of them is kind of subparts, which is subparts under the main topic that courts are willing to find statements that form the basis of these kinds of putative class actions to be not deceptive as a matter of law. And they're willing to do that for a number of reasons, but one of them is that there's no actual representation. That's kind of one subcategory. There's no statement on the packaging at issue in relating to alleged false advertising on which a claim could be based. The package simply doesn't say what they say it said. That's one type. The other type is it's just what I call the smell test. It doesn't pass the smell test for a reasonable consumer, and courts have been increasingly willing to make that determination at the pleading stage as a matter of law without even getting into the stage where you're filing a motion for summary judgment or something like that.
We back up just for a second. When you mentioned these cases involving no representation, that the advertiser or manufacturer is not making the representation or statement that the plaintiff says they are. Can you give us an example of a case like this? Is it simply an instance where the plaintiff is misrepresenting what the advertising is, or are we talking about advertising by way of images that don't make an actual literal representation?
Yeah, I mean, one of the contexts where this came up is in the factory outlet context, and the case that I cited in the article is the Rubenstein versus the Gap, which is a case where the plaintiff alleged that she was misled by Gap selling clothing in the factory stores that had not been sold in traditional retail stores that you'd see in a mall, for example. And by factory store, I mean a factory outlet.
Right.
So when you go by an outlet mall, her contention was she thought that those clothes would be the same thing that you would get in a brick and mortar retail store in a traditional setting.
Whether that's an assumption she picked up. How? That's just kind of a custom or something floating in the air that's not written on the outside of the building, I take it.
Right. And it's, I think a lot of people make that kind of assumption about certain things, but that doesn't mean you have a claim against somebody.
Yeah.
And, you go to a factory outlet, they're not saying that this is, precisely the same goods in every circumstance that you would get if you were to go to a place in, the Santa Monica, the 3rd Street Promenade or something.
Yeah. So is the essence of the claim is that there's this rumor that I'm supposed to be able to get these novel and nowhere else to be found merchandise, and Gap had a duty to dispel that rumor if it was in fact if it knew it was not true and that rumor was out there. Is that kind of the essence of the plaintiff's claim in that kind of a case?
Yeah, the plaintiff alleged that this is a quote, reasonable consumers believe outlet stores sell products that were previously available for purchase at retail stores. So the plaintiff actually alleged that, but the court explained, and this is at the pleading stage, there were no facts showing that to be true. And that a consumer for whom the retail history of factory store items is material can ask Gap employees about this. And a reasonable consumer would inspect the quality of factory store clothing items before buying them and can return them if they were unsatisfactory. That's what the court determined. Yeah. So if you, for some reason, thought this notion you had in your mind that you developed through popular belief or whatever it is, what was actually the fact, and you go to this store, you could, number one, ask somebody at the store if this was true. And presumably they tell you, we have goods here that are made in a different or same factory, but they're different. Because that certainly happens a lot, factory stores can very often carry goods that are not the same line that you'd find in those much more expensive locations.
Yeah.
And they're not always, stuff they couldn't sell or out of season items or last year's items. Sometimes they are, sometimes they're not. But, people have the ability to ask questions and make informed choices based on that. And if you don't have it'd be one thing if a retailer was saying this is the same thing you'll find in our store in, X fancy mall. We're just selling it as last year's model or last year's colors or whatever at a discounted price. It'd be another if they said it's just simply the same. You just, you came here to this outlet mall and so you can get a deal. But that's not the case. Neither was the case in this instance. And but also, the court made the point that you can look at something and determine if you like the quality. You have it in your hands, just take the item and look at it, put it on, like you would in any store. Go to the changing room and try it on. Check out the quality. Is it the same sort of quality that you came to expect? Is it, if not, don't buy it.
Yeah. Well, and that leads to one of my takeaways from after reading your article. Maybe you can tell me if my takeaway is too broad, but I was left with this general impression that courts are going to be they're becoming less likely to find that consumers are likely to be deceived. The courts seem to assume a little bit more sophistication on the part of the consumers. Is that too broad a takeaway, or is that you think that's kind of the trend that you're seeing?
I don't know that it's necessarily assuming more sophistication. I think they're just imposing, or not even really imposing. They're applying the reasonable consumer standard, which has been around for a while, but they're making it rational, in my opinion. Obviously, I come at this from the defense standpoint, but I believe in what I do very strongly, and I know why these laws were enacted, and they certainly have their place for the correct circumstance. But in a situation where something is not something a reasonable consumer is going to think is deceptive, courts are just willing to look at that and go, I'm not going to force this defendant to spend months or years litigating this to the class search stage or beyond, at a cost of potentially many hundreds of thousands of dollars. When, look, I mean, come on, it's obviously not deceptive to just a rational, reasonable person. Just look at the statement. I mean, who's going to think that the term crab mixed with the K is made with real crab? What kind of
I love that one.
Unless you can't spell it all. And that's the Kang versus P.F. Chang's case in the article, and I think that is something the judges should be entitled to do. That's why they are, appointed in the case of federal court or elected in the case of state court to do what they do. We trust them to be rational and make these kinds of initial determinations and frankly prevent the courts from getting clogged by these no harm cases that are based on allegations that don't pass the smell test. Yeah. If that makes sense.
Yeah, that was the holding of the Kang versus P.F. Chang's China Bistro case, that crab meat, K-R-A-B, crab meat, would not lead a reasonable consumer to believe that it was real crab, C-R-A-B, crab meat. So, let's go back to, you mentioned we're talking about the reasonable consumer test here.
Right.
And as I understand that test, it means that it has to be more than just likely or possible that someone out there would be misled. There has to be a finding that a substantial portion of the target market would be misled. Do I have that right?
Yeah, I mean, and it depends on the nature of the case. In a lot of cases, the target market is, any reason. It could be huge. It just, it depends on what the product is.
Yeah.
Whoever's going to buy that particular type of product are likely to. And that's the same thing for trademark infringement cases. When you're talking about likelihood of confusion under this case called Sleek Craft, which is the Ninth Circuit test for likelihood of confusion. And one of the things that you need to show, is particularly with the survey in those kinds of cases, is that your sample for the survey, it draws upon likely consumers of that product. So it's a similar concept. But I'll give you another example, which is the Disha Hodges case versus King's Hawaiian Bakery West, also discussed in the article. Some of the other things that come into play here is the actual packaging as well. So not just whether a particular phrase is so obviously not deceptive as a matter of law that it's not going to pass that test, but also, look, in that case you had it was called King's Hawaiian Original Hawaiian Sweet Rolls. And I think a lot of people are aware of this bread,
Sure.
Which states on the package is established 1950 Hilo Hawaii, inside a 3-point crown, which, is evocative of the pineapple's crown. But on the back, it says it's now made in Torrance, California. It says it right on the package. And that's an interesting case to me because it's the court said, unlike the brewing process, and I found this interesting having been a brewery owner, the place of origin is not as important to consumers in the court's mind. It's not relevant. Whereas in brewing, it can be relevant because of the quality or type of water, and which makes up over 90% of the end product. I found that interesting because I'm a brewer. I was a home brewer before I owned a brewery. And, there are situations where if you're a beer aficionado and you want to get a Kolsch in Germany in Cologne, it's got a very specific water profile. You want to get an Alt in Dortmunder, it's got a very specific water profile that really affects the taste of the beer. So I was surprised to see the court pick up on that particular notion.
Oh,
But it said,
that is interesting. So does that mean that King's Hawaiian bread, with the package that says on the back somewhere made in Torrance, California, that's not unfair advertising, but what if King's Hawaiian made a line of beer, King's Hawaiian Pilsner, and on the back of the can it said made in Torrance? Would that be a different result because it's a different product, different target market?
I don't know. That's an interesting issue, but I think what it's going to depend in part on the product and upon whether geographic origin is relevant to the quality of the product or some unique aspect of it. If there isn't a description of where it actually comes from in that instance on the packaging.
Yeah. I was just going to ask the distinction between Torrance and Hawaii and bread and beer. Is that often made at the pleading stage or the summary judgment? Is expert witness required, expert testimony required on some of these issues?
Well, in that case, it was done at the pleading stage. I think if the product doesn't make a representation as to geographic origin, it seems to me to be fair. And the nature of the claim is I looked at this packaging and I thought it did, then I think it should be ripe for consideration by the court as a matter of law. It doesn't, or if it's got a disclaimer as to geographic origin. I thought this was from Hawaii. I didn't bother to look at the part of the package that says it's from Torrance. And the court said in that instance, you're being selectively blind was the phrase the court used. And I think that's spot on.
Yeah.
So, it's certainly important to have packaging that's not deceptive, that doesn't, mention things that aren't true, doesn't make representations that aren't true. But if you don't, then I think it's great that courts are willing to take this up as a matter of law and make this kind of decision up front.
Where is that line between where it's a factual issue and where it's an issue of law? If the plaintiff is arguing in opposition to your demur on behalf of the business owner,
right?
You're arguing that no, this should be an issue of law. The court can find as a matter of law that there's no there's no deception here, and the plaintiff is arguing Your Honor, this would be stealing it away from the province of the jury. This should go to a trial. You'd be denying my client his or her day in court. What's the argument there? How do you push the judge over into your camp to decide that this is an issue that we can decide as a matter of law?
It's in the judge's discretion and in their minds. Really, they're substituting their judgment for reasonable consumers in a way that I think makes sense because they have a duty not to allow their docket to be clogged with nonsense. I mean, I make no bones about where I come out on this stuff, but I think I do for a reason. And I think that's what this is all about. I mean, you're going to get that argument on the other side in every instance, that this is, why are you doing this now? We should be able to take this to a jury. We should be able to do a survey, and we'll talk about that in a minute. Or sometimes they'll increasingly include allegations in their complaint about a survey, which ties in again to trademark litigation. That's a lot of the survey experts who get involved in these kinds of cases are the same ones you would use in a trademark infringement case.
Yeah. Well, let's talk about surveys. I assume that this is a strategy that got cooked up by plaintiffs' attorneys after you and your colleagues were successful in getting a lot of these issues adjudicated on demur stage as issues as a matter of law. And so plaintiffs probably decided, we got to make this clear that this is a question of fact. And so let's get a survey put together. And so do the plaintiffs allege that there exists a survey and put the survey results in the pleadings themselves in order to buttress themselves at the demur stage?
Yeah, absolutely. And again, and increasingly in my experience, courts are willing to overlook those allegations in the face of statements that the courts determine are not deceptive to reasonable consumers as a matter of law. So in some instances, they point to obvious flaws with the survey, and survey methodology. But in other cases, they just basically reach the conclusion that, a self-serving survey is not going to change the fact that I just simply don't find, the court, do not find this to be deceptive as a matter of law. But I'll give you an example, is the Clark versus Westbury Natural case cited in my article. There the plaintiff alleged that a survey showed that reasonable consumers would conclude that vanilla soy milk that had the vanilla flavor came from the vanilla bean specifically, although that wasn't represented on the packaging. And they claimed to have a 49.66% response rate, basically confusion rate, showing that. But the court pointed out flaws with the survey, among the fact that they didn't have when they were asked about whether the label conveyed anything about the origin of the flavor, nothing was not even an option. So there's Sherry Diamond's survey evidence chapter from the federal manual on scientific evidence is kind of the gold standard on this issue, and it's really it boils down to a number of issues that you can point to, but this was one of them. If you don't have nothing as an option in your survey instrument, it's a fatal flaw right there. And a lot of times the questions
was that decided at the demur stage?
What's that?
Was that decided at the demur stage or summary judgment?
Demur stage.
Demur, that's interesting.
I believe so. That's a good question. I believe that was also at the demur stage, but I've seen this happen at the demur stage. And a lot of times, at least in the surveys that I've seen, I have yet to see a survey that's described, and in some cases attached, that follows the basic requirements that you would follow in conducting a likelihood of confusion study in a trademark infringement case.
I did just check your article. It does say that it was that the defendant's motion to dismiss was granted on those survey methodological errors. So that is interesting. That's something very important, I would think, for defense attorneys to keep in their back pocket, to know that they don't have to wait for summary judgment or trial to adjudicate methodological problems with the plaintiff's surveys.
Right. And then I've cited a couple other cases in the article too on this issue. The Elbaz versus Vitals International Group case there, it was kind of a vague reference to having surveys in hand, but they didn't allege any details. That was at the dismissal stage as well. The Scovia versus Gruma Corporation case was a tortilla case, where the court felt that it was simply not plausible that reasonable consumers would be misled into believing that tortillas were made in Mexico when they had a statement on the packaging saying that they had contained a piece of Mexico, and which the court found to be a meaningless phrase. They did give the plaintiff, however, in that case, an opportunity to try to allege survey results. So sometimes they are willing to be more, amenable to that. So I think it depends on what, if you're gonna, I don't know, I like I said, I've yet to see a survey in this kind of case on the plaintiff's side that supports the allegations that are made in a way that I think would pass muster under Sherry Diamond's principles, which are the ones that every survey expert follows. And I've done, panels and written about the survey issue. It's something that is of unique interest to me. Defended and taken a number of expert depositions on survey issues in particular. It's kind of an interesting area, and so it's near and dear to my heart. And I'm glad to see that there are judges who take a look at some of these instruments and say, no, this isn't going to work. I mean, leading questions, for example, not having a question that no or I'm not deceived is an option, not having a proper survey universe. I mean, there's a whole host of things. There's kind of a checklist that you go through. And if your expert is someone who's good, they're gonna follow those rules whenever they conduct a survey. So
I imagine when there's a case-ending order at the demur stage, plaintiffs often appeal those rulings, and when there's a lack of a case-ending order at the demur stage and the demur is overruled, sometimes defense attorneys will take this up on a writ. So whether it's on a writ or on an appeal, are there any common issues you see up when the cases are up on a review? Are there any traps that attorneys need to be aware of in terms of pleadings battles over these types of claims?
At the appellate stage, well, I think it's kind of like, if you managed, you're saying if you're on the defense side and you manage to have your demur sustained without leave to amend,
Yeah.
or a motion dismissed granted with prejudice, what are you looking
Right.
for on appeal?
Yeah. Like, for example, on the question of surveys, I wonder if it's if trial judges can sometimes overstep the line between fact questions and legal questions in terms of these statements and whether or not it's an affirmative representation or an omission and that kind of thing. And
Right.
have you seen any issues that come up commonly in dealing with either appeals or writs on these issues?
Not really, because I think, in most instances, the battles are about these same issues as a matter of law. So
Yeah.
I think just dotting your I's and crossing your T's in terms of your arguments below, and making sure that you're on top of the law because it changes so often, and try to make sure that you gather as many of the decisions on these points in your favor as you can, because there are splits on a lot of these sub issues. And so I wouldn't say that there have been final pronouncements on a lot of them. So
you ever have situations where you're partially successful on a demur and you're able to kind of kill the core claim and the plaintiff's complaint, but the case is not completely finished? Sometimes in those kinds of instances where the case still hobbles along, the plaintiff might be motivated to just dismiss the rest of the claims in order to accelerate the appellate review. Do you ever see those kinds of issues? Do you ever have plaintiffs asking you to stipulate to a dismissal and reservation of appellate jurisdiction, those kinds of things?
No, I haven't personally. I think it would be interesting to see how, though, depending on what they do and what they dismiss, that could trigger some issues under Sonner as well. And I'd be interested to see how that might play out.
As a defense lawyer on these unfair competition claims, where would you rather be, state court or federal court, in terms of which form is more hospitable to UCL claims?
I know there are people who will say that they'd rather be in federal court, and there is some truth to that from the defense side for a variety of reasons. But I found that I really like a lot of the complex judges. I think you get a very fair read from many of them in state court, and I really like a lot of them. But I would say overall, I would rather be in federal court, not because of the judges, but because I think there are good ones in both state and federal court, of course, but rather because you can take advantage of the federal court's view on Article 3 standing, for example, and issues like Sonner. which is a Ninth Circuit decision that can be really helpful in federal court as opposed to state. I also just think because of the institutional way that federal courts work, and how dockets have become so backlogged after COVID, a lot of times you can get a quicker read or a quicker decision, depending on which judge you're in front of. It can go both ways. I've had judges in federal court take over a year to rule on a motion to dismiss, or I'm sorry, a motion to compel arbitration, to the point where the client just decided to resolve the case because we couldn't wait any longer. But I've also found in some state courts, it's taking 6 to 8 months to get a hearing on, a dispositive motion. So I just think overall and because I do a lot of intellectual property litigation, I'm very comfortable in federal court. I'm comfortable in both, but
yeah,
I think a lot of times plaintiffs' counsel in these kinds of cases is not comfortable in federal court. So I'd like to be where there's an imbalance of comfort, if you will. That certainly helps. But for those reasons, and substantively, I think it's a better place to be for defense counsel.
Hey, I've never really litigated either side of these claims. And so far, pardon my ignorance, does insurance typically cover these claims when a business is sued for a UCL claim?
Oh, it depends. False advertising. It depends what kind of insurance you have, really.
Yeah.
It can run the gamut.
Well, let me ask you this. Many lawyers practice toaster law. They practice whatever pops up, right? They're generalists. When does somebody need to call Greg in to handle a UCL claim?
I think at the pleading stage, if you've gotten hit with one of these, there are so many traps for the unwary, in the sense that you can leave a lot of arguments on the table without realizing that you just gave something up. And just the nuances that are coming out, for example, under Sonner. It's interesting to see how the district courts are applying that decision, and there's all of these micro splits, if you will. So it's really important to be able to marshal as many of the favorable district court orders as you can. And I've also noticed something interesting, which is, used to be that you couldn't cite district court decisions from Westlaw like anywhere, and now it's just all bets are off, it seems to me. I've had no problem whatsoever doing that in either state or federal court, frankly. And that's really helpful, because a lot of times that's the only place where you're going to find a particular nuance or a particular discussion of a case like Sonner that's come down, and how are we going to actually apply this now on the ground, now that this case has come down? How are we going to look at it in light of this particular nuance of this set of allegations in this complaint, on this motion to dismiss? So
you've mentioned Sonner several times now, so let's finally get to the Ninth Circuit decision in Sonner versus Premier Nutrition Corp. So this is a doctrine now that comes up in federal court that can limit plaintiffs' availability for or entitlement to equitable relief if there is an adequate remedy at law. So that's the holding under Sonner versus Premier Nutrition. So, Greg, how does this come about under Sonner? If a plaintiff is seeking both equitable and legal relief, does Sonner just mean that, sorry, you can't get the equitable relief, you're only you can only look at the legal relief?
If you allege an adequate remedy, if you allege a claim for which there's an adequate remedy at law, yes. And in some of the cases, like the Jialu Wu case discussed in my article, there the plaintiff sought both restitution and injunctive relief, and the court found that was a distinction without a difference. You have to plead the inadequacy of legal remedies.
Okay, so that's an important
unavailability. I'm sorry, go ahead.
That's an important pleading note on the checklist, then, to make sure that you, if you're asking for both, you have to make sure to establish that legal relief by itself would not be adequate. You need the equitable relief as well.
Right. And so one area where this can come up is if you allege a claim under the CLRA for which damages are available. At the same time, you allege a claim under the UCL or FAL or both and seek restitutionary disgorgement or injunctive relief. And restitutionary disgorgement is under Business and Professions Code section 17203 is not what you might think it is if you don't practice in this area. It's the California Supreme Court has held in a number of cases that that doesn't include lost profits, for example, that the other side may have realized or earned as a result of alleged unfair business practices. It has to be money or property that you either had in your possession and turned over or paid to the defendant, or that you have a statutory right to obtain, like overtime wages, for example. Once you earn overtime wages, that's a right that attaches to you individually as a person under California law, under the labor code. That's a present right to receive those wages, right? But and in a case called Korea Supply, for example, you had a defense contractor who lost out on a bid to another one, and tried to seek the profits that the company that won the bid, as by virtue of what they claimed were unfair business practices, tried to recover those as restitutionary disgorgement. The California Supreme Court said, no, that's not what that's all about. That's in essence damages in disguise, and you cannot get damages under the UCL. So because of that, you would very often see, up until Sonner anyway, the triumvirate. You'd see UCL, FAL, and CLRA, because the CLRA just straight up lets you get damages. And so now one of the issues that's come out of Sonner, and you'll see a lot of back and forth in the district courts on this issue, is Sonner was further along than the pleading stage. Does that mean that you have to be further along for this doctrine to apply? In other words, can you allege in the alternative? Can you allege these claims in the alternative and get by a motion to dismiss? I think the correctly decided district court cases say that doesn't make a difference, because it's obvious from this claim that they're seeking damages. So there are plenty of district court decisions where they will still dismiss the claims at that stage, but there are others that won't. So that's one issue. The other issue is if you're seeking future injunctive relief as opposed to relief for past conduct. And that's what came up in this, one of the issues that came up in the Gialu case cited in my article. The court rejected that argument that the plaintiffs were seeking relief for future violations based on automatic renewals relating to these television subscription services. And interestingly, the court in that case rejected plaintiffs' argument also that they were only seeking relief under the UCL, because the court found that the nature of the relief was legal. So this is a really hot area. I mean, as I said, 300 and something district court decisions applying Sonner, and this is why it's important when you get this kind of case to make sure you find somebody who understands this area of the law and is going to marshal as much as possible, in your favor if you're a defendant who's been hit with one of these claims.
Okay, and then the Sonner case is fairly recent. That was 2020.
Right.
Was that the first case in this space in the Ninth Circuit?
Well, they were resolving, as I recall from that decision, and I know this issue came up before in the district court level, so they were resolving an issue that had not yet been resolved at the appellate level. Yeah.
Well, like you said, this is a space to watch, the interplay, or to what extent a plaintiff can plead and recover both legal and injunctive relief. That may be a landmine, and I know that you represent the defendant side, but I would say that if you're a plaintiff's attorney listening to this, it seems like it could be malpractice to bring a claim in federal court if your client really wants both legal and equitable relief.
Yeah, here, one other interesting nuance I should point out on that is, and this is not, there are different district decisions on this as well, district court decisions, but what happens if you allege this claim under the CLRA, you allege these types of claims, and one of them's under the CLRA, and you seek damages. And then just before trial, you dump the CLRA claim because you want to avoid this issue and just get a bench trial because it's all equitable at that point. And there are cases that say, no, sorry, nice try.
Yeah.
You make the decision to do that, you do so at your peril because you could have the whole case thrown out. Except for potentially injunctive relief, but it depends on the case.
Okay, so those are the trends we've covered. That it looks like that judges tend to be imposing a little bit more of a rigorous standard on the reasonable consumer, the consumer test. Watch out for Article 3 standing issues in federal court, and then also make sure that you're looking at the Sonner versus Premier Nutrition Corp. If you see a case in federal court that alleges both legal and equitable remedies. Anything else that our audience should be aware of as a kind of a parting shot here, Greg?
I think one of the things that if you're at the summary judgment phase of a case, I think one thing that's really important to remember is to really dot your I's and cross your T's in trial court on the evidence to support your motion. Because I have seen this time and time again come up where you need to have, authenticating declarations for exhibits, for example. This is not a jurisdiction where documents are self-authenticating. So you need to make sure that you have proper, declarations supporting your evidence, follow all the rules, make sure your separate statement. I mean, it's in the rules of court, but I'm just shocked how many times the separate statement doesn't look like what the rules of court says. Just, do this. Here are the columns. Follow this format, and then you just get some wacky thing.
They even give you a picture right in the rules of court.
Yeah, exactly. So if you want everything has to be done right if you want to survive appeal.
Yeah.
No matter what side you're on. So that was kind of my parting shot on that issue.
All right. Well, Greg Nylen, thank you very much. If any of our listeners are representing a defendant facing a unfair competition case, you should give Greg Nylen a call. Make sure you are not missing any splits or unresolved issues or any defenses that you need to raise, or else they ever be deemed forever waived and forfeited if you ever have to get to an appeal. All right. Well, once again, Greg Nylen, thank you very much for being on the podcast. And Jeff, that's going to wrap up this episode. We'd like to thank our sponsor once again, Case Text, for sponsoring the podcast. Each week when we include links to the cases we discuss, we use Case Text, and listeners to the podcast can find a 25% discount available to them if they sign up to Case Text at casetext.com/CALP. That's casetext.com/CALP.
And if you have suggestions for future episodes, or if you have a strong opinion about whether Hawaii or Torrance makes better water for bread, please email us at info@calpodcast.com. And in our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
All right. Thanks. See you next time.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.